Here. Hi, everyone. This is Michelle Canero here. We're going to wait for our Instagram Live to go up so we can have everybody joining. Thank you for being here today. Today's conversation is going to be in English for those of you that were perhaps in the talk we did, the live we did yesterday that was primarily in Spanish. Today, we're going to address the same points in English. So for those of you that don't know me, my name is Michelle Canero. I'm an immigration attorney. I practice out of Miami. I've been practicing for over 20 years now and, practicing exclusively immigration. I do a lot of business immigration, but because of my clientele, the fact that I'm Venezuelan, a lot of my clientele is Venezuelan. I also do a lot of humanitarian, TPS, asylum, family, citizenship, and now removal defense work. Unfortunately, I didn't think that this would come to that kind of adversarial immigration practice, but because my clientele are primarily professionals, people that have come to the United States lawfully, have followed the rules in terms of how they, apply for things and the conditions that they've met. But given this administration's changes in policies, a lot of people that have historically been treated as lawful immigrants are now being considered illegal immigrants and seeing the penalties and repercussions we normally associated with, people who broke our laws or were criminals. Unfortunately, this administration has conflated legal and illegal immigration, and now all immigration is under attack. So this new memo is the latest blow, and quite frankly, I think the most egregious step against lawful immigration that this administration has taken. And with it, I think they're saying the quiet part out loud, right? We hear that phrase. But the talking points of the campaign, where we are going to stop illegal immigration, close our borders, and protect Americans. While the underlying message was always that immigrants were other and unwelcome. That is now clear. There is no distinction for this administration between legal and illegal immigrants. They are clearly trying to reduce the immigrant population for generations to come. And this is the next step in what is going to continue to be an aggressive shutdown of our immigration system. So on Friday, DHS published a memo that they claim clarifies the existing standard for adjudication of green cards and what we call adjustment of status. Now, for those of you that are on this call, I'm assuming you're very familiar with these terms, but maybe you have someone joining you that isn't so clear. Maybe you need to talk to someone that needs to understand this. The way our system of immigration works is that we have two categories of visas. We have non-immigrant visas, which are visas for temporary reasons, limited time, limited purpose, right? We have tourist visas, we have student visas, we have work visas, we have diplomatic visas. So these are non-immigrant visas. And people can use these to come to the United States lawfully and be here for the period of time that those visas allow. Now, if someone wants to reside here permanently, usually they are on a non-immigrant visa, right? So they've come here and now they want to reside here permanently. They need to do what's called an immigrant visa application or a green card. What does that entail? First, you need a petition, right? So normally that requires either a family to sponsor you or an employer to sponsor you. In the employment categories, we also have self-sponsorship for people with extraordinary abilities, business owners and entrepreneurs, national interest waiver applicants, and we also have the investors on EB-5 that can self-sponsor. So those are the two categories of petitions. Now, if you have a pending or filed petition and you are lawfully in the United States, decades ago, Congress enacted the rule of adjustment of status, What does that mean? I am in status and I want to change from a temporary non-immigrant status to a permanent green card status, okay? That is what adjustment of status means. Change of status is when you go from one non-immigrant to another non-immigrant. That is not affected by this process, right? So somebody who's on a tourist visa and changes to a student visa, they're not affected. Somebody who's on a student visa and changes to an O talent visa or an H work visa, that is not affected. This is only for people that are moving status from one temporary status to a green card. There are exceptions on the adjustment of status where somebody who is not actually in status may file for adjustment. And that is when you are the spouse, minor child, or parent of a US citizen. Okay, these are what we call immediate relatives. And Congress, recognizing the importance of keeping a family together, made exceptions for those categories, saying you don't have to have lawful status at the time of filing adjustment to qualify for the green card. You just have to have entered the United States legally, right? So they'll forgive certain violations. So everybody who's here, whether they're married to a US citizen, whether it's through employment, whether through it's a national interest waiver, whether through it's an EB-1, whether it's extraordinary ability, whether it's through an EB-5 investor visa, whether it's through a relationship with another American citizen or lawful permanent resident that has filed for an adjustment of status or will be filing for an adjustment of status, is now affected by this memo. And what does this memo say? This memo says that adjustment of status is a privilege that will only be offered to people who can meet an extraordinarily high criteria in order to merit the favorable discretion of the officer adjudicating that case. That is not the law. The law actually, under a precedent that has been established for many years, under a case called Matter of Array, says that there is a presumption of approval in an adjustment, meaning you are presumed to be approvable unless there is an inadmissibility, something in your application that makes you ineligible for the green card. And Congress made a list of these things, right? They said if you committed certain crimes, you're ineligible. They said that if you've been unlawful for a certain period of time, you are ineligible. They say if you entered without inspection, you are ineligible. What they are now saying is, even if you're eligible under all the criteria that the Congress enacted, even though there is this presumption of approval, even if you meet all the criteria of eligibility, they are now going to invent a new standard similar to a hardship waiver to make you have to prove that you are worthy of a green card here in the United States. The simple fact that you are filing an adjustment of status is now considered a negative factor. When you file your adjustment of status, if you are unable to continue to maintain your previous status, for example, students, they can't renew their student visa after they filed their adjustment. Somebody who's on an O visa, they have a new work authorization through their adjustment and they can't really renew the O. They have let their status lapse. Now that is considered a negative factor, even though the only reason that it's a negative factor is because the government took too long to adjudicate your case, because at the time of filing, you were lawful. If you've had any prior immigration violations, ever, you overstayed your visa once a long time ago, you worked without authorization once a long time ago, even if those things don't make you inadmissible or ineligible under the Immigration and Nationality Act as enacted by Congress, those are now negative factors that count against you. So we are looking at all these invented negative factors. You already have negative factors by simply having filed the adjustment of status, and the conditions under which you filed it, which are perfectly legal, are now going to be considered adverse factors. So you have to now prove positive factors that outweigh the negative. And there isn't a clear weighting test, right? We don't know if they're going to take the position that one negative factor far outweighs 10 positive factors. There isn't a scale that tells us how they're going to weight the positive and the negatives in the memo. But they did indicate there are certain things that they will consider positive, right? So paying your taxes, showing you've paid your taxes, showing you have a stable job, long-time residence in the United States, so you've been here for a long time, a clean immigration record, right? So no adverse consequence. You maintained your status, you never violated your status, you never overstayed a visa. Showing that you have investments in the United States, properties, businesses, community service, community engagement, recommendation letters from churches, charitable organizations. These are positive factors that they're looking for you to document, prove, and argue to essentially beg the US government to grant you a green card here in the United States. And the worst part about all of this, quite frankly, is that the government arbitrarily decided last year that there are 39 nationalities that are not eligible for green cards abroad at their home country consulates. And they expanded that list to 75 when they created this new public charge rule that they're going to start considering at the consulates. There are only 191 countries in the world. 75 countries, by order of the president, are not allowed to get green cards abroad. So if now, under this new memo, that presumes that consular processing is an option, these people who can't go home to get their green cards now can't process them here. We have nationality discrimination, and they are arguing it's legal. So it is very clear that the purpose of this entire scheme is to reinstate, in my opinion, very racist quotas that existed before President Kennedy changed our immigration laws. And that is why the countries that are not on the visa bans happen to be of a certain ethnic stereotype, right? So I think we have to take a very clear view that the purpose here is to block large groups of immigrants from applying for benefits that they are legally entitled to. Now, in my opinion, it's a scare tactic, right? This memo does not have real teeth when it gets under judicial scrutiny, which is why we are collaborating with several other law firms and co-counseling with experienced federal litigators to bring a lawsuit on behalf of our clients to challenge the applicability of this memo. We are not doing a class action. A class action requires class certification, and that can take years. We're just not in a position financially to do that. We're not an ACLU with millions of dollars of resources and, you know, a giant white shoe law firm behind us offering us thousands of free pro bono hours. We are a small group of smart, hardworking attorneys who want to make a difference for our clients. So this will be what we call mass impact litigation, in which we will be filing the lawsuit on behalf of our named plaintiff clients. Our initial relief is going to be requesting an injunction or a TRO, a temporary restraining order, to protect our clients from being subjected to this new memorandum. We have multiple arguments, which we are advancing in the memo. One of them, obviously, is that this is arbitrary and capricious. It violates the Administrative Procedures Act. There was no notice and comment. It is a significant rulemaking change. This is not a reinterpretation of an existing policy. This is a complete revamp of our immigration system, and it directly contradicts what Congress enacted as the legal pathway for immigrants in the United States that wanted to pursue their green card through adjustment. We will be inviting our clients to participate in the litigation. Right now, anybody who's interested can email litigation@cfrlaw.com. The lawsuit onboarding documents are going to go live today. We've just been beta testing them. The litigation is going to be for any applicant for adjustment of status, and either family-based or employment-based, that has their adjustment of status pending and hasn't been adjudicated. So this means even if you have an EB1, an EB2 national interest waiver, a PERM, an I-130, and they're already approved, those petitions, but your adjustment of status is still pending, the memo applies to you, and participating in this lawsuit, our goal is to protect you from scrutiny under the memo through judicial order. Pending adjustments of status are welcome to participate in the lawsuit. If you haven't yet filed your adjustment of status, you cannot participate yet, but we may be able to include other plaintiffs later in the litigation, depending on how quickly the judge rules. We are hoping to get preliminary relief in the next couple of months, meaning in the next 60 days would be our goal. We plan to file the lawsuit next Friday, maybe even sooner, which is why the cutoff date to join the lawsuit will be this Friday at 5 p.m. So, in 3 days. We are working overtime for our existing clients. This is much easier. You just need to sign the contract and make the payment. We have all your documents. If you have friends or family that are not our clients but are interested in participating in the lawsuit, they may do so. The web page that we will be sharing to onboard clients will allow them to upload their receipts and put their receipt information. The information we're going to need from everybody that participates in the lawsuit is the petition receipt, so the I-130, the I-140, or the I-526 receipt if you're an EB5, the I-485 receipt for each family member. So you can't just do one member of the family. You have to do the whole group if you want everybody protected, right? And then the fees to participate will be $4,000 for the principal applicant, $2,000 for the spouse, and $1,000 for each child, up to $8,000. That means a family of 4 would pay $8,000, but then if you have more than 2 children in the family group, you don't pay more. We cap it so that large families aren't penalized and can be included, because we want to make sure that everybody gets protected. This litigation is the only way that I can offer you to protect you from the applicability of the memo, okay? Right now, there has not yet been a class action that has been filed or certified on this memo. I am assuming that there will be additional litigation, but a lot of this class action litigation has failed, right? We saw this with TPS. The Supreme Court took it up on cert and said that while they are taking it up on cert, the government's termination will continue. So if we have a class action and the Supreme Court takes it up on cert, we could end up with this memo being in place for the next year, people being denied under this memo, and the Supreme Court not yet deciding the case. Here are the real risks with the memo. If you get denied under this memo, an adjustment of status, that is a non-appealable decision under Patel. The policy of this administration, if they deny an adjustment of status, is to issue a notice to appear. If you get placed in court proceedings in a notice to appear, and you don't have a valid I-94, right? So you didn't maintain your H, your L, your O, your student visa while your adjustment was pending, which most people don't. I have a lot of clients that actually filed adjustments on TPS. They have no way to extend that status. And asylum, a pending asylum is not status and doesn't protect you. So if you get an NTA and you get placed in proceedings, they can order you removed. And if they order you removed, it's a 10-year penalty. And there's no waiver available. You just have to stay out for 10 years unless you're married to a U.S. citizen or lawful permanent resident, or you have a U.S. citizen or lawful permanent resident parent that can argue would suffer extreme hardship. And even then, you have to do a waiver. It takes several years to get the waiver and the permission for reentry. So you're going to be stuck outside for 5 years. Even if you have approved EB1, EB2, EB5, a PERM, an approved I-130. This is the goal. The goal is to eliminate immigrants' future applications for the next 10 years. So my first recommendation is anybody who has an adjustment of status pending should participate in this lawsuit. How are we going to protect our clients generally, right? So lawsuit is step one. Second avenue of attack is we are going to be addressing the memo head on. I have drafted a legal brief. I've done extensive research over the course of the weekend. I have a strategy on how I'm going to document the equities. Unfortunately, it's not cookie cutter because the equities, kind of like a waiver, have to be argued particular for each case. So we are going to have to do declarations from your employers, from community leaders. You're going to have to do an analysis of your tax returns. We're going to have to do declarations outlining your particular hardship. We might need to get declarations from your US citizen LPR family members that would be harmed by you having to leave and process your immigrant visa abroad. So we're going to document the favorable equities. Then we're going to have to do police clearance letters to show you don't have any negative equities. Those of you that have criminal issues, arrests, citations, those are going to be negative equities that we're going to have to overcome with positive equities. Anybody who overstayed or no longer has status, for example, you were on TPS and it got terminated, we're going to have to make those arguments that shouldn't be considered a negative equity because it was out of your control and it was the government that terminated the program. But we need to have enough positive equities to overcome that. If you filed an adjustment and you're subject to a visa ban, we're going to make arguments that you had no other choice. The memo presumes that you are you have an opportunity to consular process. But the reality is, for 75 countries, consular processing isn't even an option. They've also eliminated third country national processing, which means that if you are afraid to go back to your home country, you filed asylum, or you just have a fear of going back home for reasons of persecution. A lot of Russians, Ukrainians, Venezuelans, Somalians, people of different sexual orientations, depending on discrimination in their countries of origin. There's a lot of reasons why people may not want to go back to their home country to process their immigrant visa. Well, with the new policies where you're not allowed to process in another country, again, they are precluded from consular processing. So these are all the arguments we're going to be making in these supplemental memos. Now, I can't supplement an already filed adjustment of status unless they issue a request for evidence or we get scheduled for interview. So those of you that have an adjustment of status, we will be sending out communications to clients in the weeks to come about documents you can start collecting in the event of a request for evidence. So we're not running and scrambling to get it done when that request for evidence comes in. Although typically you get 87 days, which is more than sufficient time for you to do your documentation. So we will attack clients that have pending adjustments. We will attack those issues as they come up, either in a request for evidence or at interview. And we will prepare a supplement. We're estimating the cost of the supplement, the work that's involved, to be about 10 hours. So it'll be $37.50 for those supplements. If we are filing your case now, we are going to give you the option to include a supplement with the equities. Now, that might delay the filing of your adjustment because you can't do the supplement without the evidence. So you need declarations, you need to get those letters, we need to help you craft them. So that might delay your adjustment filing. And it will be an additional fee. That work is not contemplated in the contract. Again, it's $37.50 for the supplement. And that's for the family group because the way we see it is we're making the argument for the entire family. So those supplements can be filed with the affirmative filing, or again, you can wait for the very likely request for evidence or interview to bring up those factors. It is not necessarily required. It's not primary evidence on the adjustment. They can't make it primary evidence on the adjustment at this point unless they change the forms and go through proper rulemaking. So right now, the supplement is optional to include with the filing. And your caseworker will talk about that with you. So strike step one for people who filed the adjustment, and that's anybody with a pending adjustment, all categories, even if you've had your interview, even if you've had your biometrics, even if your petition's already approved. If you have a pending I-485 that has not yet been approved, you are subject to this memo. I suggest you participate in the litigation. 2, those of you that have pending adjustments or about to file your adjustments, we are preparing these supplements. I am preparing them as we get hired to do them. I don't have the resources to do it in advance for everyone. And there may be certain people that don't want to or can't afford the additional cost of the memo. So my suggestion to you is wait till we get the request for evidence or the interview. If you have a pending application, we'll address it then. If you're filing your case now, talk to your caseworker about what would be required for you to file the supplement with your application now. And if you want to do it, up to you, right? The third option for our clients in this circumstance, not one that I love, is, well, I don't want to do this adjustment. Let me go do it consular. Okay. So consular implies several factors. If you filed your adjustment of status already, the only way I can do the consular processing is if I file what's called an I-824, okay? And that is a form to request that they change your case from adjustment to consular. Those cases right now are taking 12 months. So you would need to withdraw your I-485, file the I-824, wait outside for a year until the I-824 is approved, your case is transferred to the consulate, and then the consulate can take however long it wants to schedule your interview. Assuming that Department of State now takes on the burden of processing the 1.5 million adjustments of status that are normally filed in the United States, waiting times at the consulate are going to get crazy. Right now, a lot of consulates have a 1 to 2 month waiting time to schedule an immigrant visa interview, sometimes more. And they have a fraction of that volume because almost all green cards are processed as adjustments. If now those go to Department of State, which is highly understaffed and undertrained, we are looking at years-long waiting times for approved petitions. So I do not recommend the third option of just going consular, because at this point, if you've already filed your adjustment between the I-824 and what's going to be inevitably long processing times at the consulate, you're looking at years to be able to come back on your green card. And if you're an employment-based petition, your employer may not be willing to wait for you that long. And also, just to be clear, that on your perm cases, you cannot change jobs. The company has to be willing to offer you that job up and until the day you arrive and for some time after. And that is the only place you can work when you come to the United States on that green card. So, I just don't think that that's really an option. Plus, we have the visa bans, right? So for 75 countries, it's not like you can even go consulate. But I'm happy to discuss that option with clients next week that are saying, you know what, I've had enough. I'm going to just roll the dice, leave, and I want to do my process from abroad. What does that entail? I'm happy to talk to you about timelines and what's involved in that next week once we've gotten through the litigation. I do not, unfortunately, have the time in my schedule, nor does my team, to discuss the litigation option one-on-one with clients. I wish I did, but that's why I'm doing these Zooms. I'm answering questions at the end of the Zooms. We're going to send out FAQs. But if you listen to these videos, any question you may have will be answered. So those are the 3 lines of attack. I'm not being alarmist. This is the agenda. They want to be able to deny adjustments of status. And by making them discretionary, by creating this weird, illegal formula for a balancing test, they could just pretty much deny every single green card application, arguing that the negative factors merit denial, because it's not that the negative factors have to be outweighed by positive. Their standard is that it is only in extremely limited, extraordinary circumstances that they will grant an adjustment of status. There are 1.5 million adjustments of status pending right now with DHS that have not been adjudicated. 1.5 million immigrants that have lawful path to a green card. And the government is likely to deny 90% of them on discretion. And when they get denied, they get placed in proceedings. The courts are not giving voluntary departure because the government is fighting them. So that means people are getting orders of removal with a 10-year penalty that they can't come back. if you have a pending adjustment, you really have to consider participating in a lawsuit to protect yourself from this memo. You cannot count on, the Supreme Court or other courts to do a nationwide injunction, because I just don't think that's realistic. We've seen it tried over and over again in the court system over the last 18 months of this administration. And unfortunately, we have failed at every turn. We did not succeed with Venezuelan TPS. We have not succeeded with Haitian TPS. I don't know what the Supreme Court is going to do with those cases, but it doesn't look too good. And I am terrified of what they're going to do on the citizenship case. You need to protect yourselves. So my suggestion is participate in the lawsuit if you can. If you can't, start pulling your equities documentation together, proof of your taxes, getting letters from your churches and charitable organizations where you volunteer, evidence of your longstanding residence here in the United States, letters of recommendation from friends, any letters from American family members you have and how they would be harmed by your departure from the United States, letters from your employers talking about the great work you do and why you're so necessary for the company. If you own a business, maybe letters from your CPA or your partners talking about your enormous contribution and how many people you employ. We're going to work all of that into your declarations and your supplements. But those are things you can begin doing. So that's pretty much where we stand on the memo, where we stand on the options we're offering our clients and the course of action that we're taking to protect our clients. My closing argument here is we just gotta keep pushing. We just gotta keep fighting and resisting, because the objective here is to scare people away. If I had been, if I'd come to this country right now and I was facing this, I would want to fight and stay here, because, I came here when I was 8 years old. I became a citizen through my mother, who was an American, and I built a life for myself here and for my kids. And I feel that everyone should have that opportunity. And every one of you that has filed an adjustment of status and is in this country lawfully and has followed the rules that were set in writing as they were, it's unfair and wrong that they try to change and flip the system on you. And I think that over time, logic and common sense will prevail. We just have to fight. And that might not be something that everybody is up for. Maybe you have better opportunities elsewhere. But I think this is worth fighting for. I think that people should continue to file their adjustments. I think we need to push back. I think we need to make the arguments that this memo is unlawful, should not apply, violates statute, violates precedent, is an improper retroactive application of policy, and should not, at the very minimum, should not be applied to people that have already filed, right? And had no choice in the matter. It should not be considered adverse factors that you followed the rules as they were. So with that, I'm going to open up to questions, and I'll stay here as long as you all need to answer your questions.
Perfect. So the first one would be Joyce Haller. If you already applied to the adjustment of status, now you should just wait for USCIS to request for evidence, or everyone needs to leave.
My recommendation is, if you filed an adjustment of status, join the lawsuit so that you can be protected from the application of the memo. We are going to request a judicial order that all members of the lawsuit be protected from the memo, meaning they can't deny you for any of the reasons listed in the memo. Everyone who chooses not to participate in the lawsuit but has an adjustment of status pending or wants to file an adjustment should continue to do so. And then we will work together to make the arguments under the memo that you are eligible for adjustment of status under existing law at the time of the filing. But even considering the memo, which we will argue is unlawful, even considering the memo, you meet the positive equities. The only cases I would be slightly concerned about are people that maybe had a lot of violations, had criminal issues, had other inadmissibility issues we were already fighting. Those may be more of an uphill battle. But that's a small percentage of our client cases. And those cases already know when you have a criminal issue, when you have a significant inadmissibility, even though it can be overcome, that it's a matter of discretion and that there is always a risk of denial. So those are the cases that I'd be most worried about and do a little more briefing. But for the most part, I would tell my clients to just continue with their adjustments and fight it as it comes up.
We have Isabella de Jaworski. Is it anticipated that a special exception will be granted for people from countries that do not have consulates like Venezuela?
No. The reality is that this policy was created specifically to bar those 75 countries from ever getting green cards. This administration does not want immigrants from those 39 countries in the United States in any way, shape, or form. So they are looking at ways to block them from pursuing their green cards abroad and in the United States. They have not lifted the bans, even though they said they'd do it after 6 months. They extended them. They have imposed additional holds, and now this adjustment bar with 0 exceptions for countries that have visa bans or that don't have home country consulates. So, yeah, no.
We have Javier Rodriguez. Me and my wife filed the I-485 in April. We got the case numbers by May 6th. Does this apply to people who have already submitted their cases, or is it moving forward after the publishing date?
It applies retroactively. It's going to apply to every single person whose green card has not yet been approved. So even if your petition, like your I-140 or your I-130 has been approved, even if you've already had your green card interview, you are still subject to this memo.
For AOS of spouse of USC, do the positives only apply to the immigrant spouse, or is the USC spouse included?
So the positives are relevant to the actual applicant, right? So the foreign national. But I am going to make the arguments that the positive factors of the petitioning spouse should also be considered. So for example, I was just talking today to a client who's a US citizen. He's a veteran and he wants to petition for his wife. Now, military service is a positive factor for the immigrant applicant, but I'm going to make the argument that since the petitioner is a veteran, that should also be weighed as a positive factor. I mean, this is an individual that fought for our country, and you're trying to deprive him of his freedom of choice to marry the woman he loves and force her to go back to Mexico and wait 4 years, which is what it's taking to consular process an I-130. So anybody who's doing an adjustment of status as a spouse of a US citizen, just know that if you decide to do this consular, it's going to take 4 years minimum, because that's how long the I-130 is taking. And there's no way to expedite it. I've already tried that for clients. It doesn't work.
We have one from Instagram. Having a US citizen child, can that be considered a positive remark? For example, I can leave the country and leave him here.
Yes. So one of the factors that we're looking at proving is hardship to US citizen and LPR relatives, right? So if you have US citizen children, the harm to them of having to consular process, right? Like, I mean, a lot of my clients are sort of mixed immigration households. So maybe the parents are foreign nationals, but the kids are US citizens. If they now have to leave and consular process, and it takes 2 years, they have to pull their US citizen kids out of school. They have to, maybe their kids don't speak the foreign language. Maybe they don't speak Spanish well. Unfortunately, my kids don't speak Spanish. If I had to move them to Venezuela right now, I'd be pulling them out of school. They'd be going to school in a country where they don't speak the language. They would suffer a lot of different harms. And that is part of the hardship that we would document in these equities memos. Again, it's almost like the standard that they applied in the memo is very similar to the 601 and 212H hardship waivers for criminal inadmissibilities. They're basically requiring people to apply for a waiver, a hardship waiver, to qualify for adjustment, which is another reason this is completely illegal. But yes, that's a good positive factor. But it's not just, You can't just say, I have US citizen kids in a form. You have to have declarations. You need to make the explanation. You need to document their academics, how their academics would be affected. We probably need to get psychological evaluations of the kids. Like, it's going to be extensive amount of work that needs to be done to really document these cases.
So another question that has been going around a lot is people that are waiting for I-140s or that haven't filed the AOS. Could they participate in this lawsuit?
If you haven't yet filed your AOS, you cannot participate in the lawsuit. But if we can, we will be trying to roll in future applicants, and we may do future lawsuits for new applicants. We just need to get the lawsuit filed as soon as possible to get the injunction.
We have another Instagram question from Doriet. How does participating in the lawsuit protect a person with a pending I-485 in the case of a denied or an RFE or an NTA is received?
So the lawsuit is going to, by judicial order, protect the applicant from application of the memo. The government has the ability to deny your adjustment for other reasons. But if they try to deny your adjustment under discretion, arguing that the positive equities don't outweigh the negative, right, which is what the memo contemplates, then they're violating a judicial order and we can have the judge intervene. The ground of inadmissibility, the standard of review on an adjustment of status under existing case law is there is a presumption of approval unless you are deemed inadmissible, right? So it's not just well, I don't like your face. I don't think you should get this, right? And that's what they're trying to create, is a system of factors that they can argue is lawful, but really is just a way to say no to people that are otherwise approvable. So the court order would be asking the judge to essentially block DHS from applying the standards in the new memo to any member of the lawsuit. And then they would have to adjudicate it under regular standards. And under regular standards, they can't just deny you unless there is an established inadmissibility, that you are not eligible for the adjustment, right? They have to have one of the enumerated reasons for denial.
We have another question. I am a citizen. Are my parents' petition affected by this memo?
If you petitioned for your parents and filed an adjustment of status, yes, they are affected.
Okay. Will this memo, the memo does not affect H-1B applicants, but it doesn't affect perm applicants.
Correct. It does not affect applications for non-immigrant visas, but it will affect anybody who files an adjustment of status pursuant to an approved perm or labor certification.
Since there is an administrative pause for green card applicants for Venezuelans, will that in some way play in our benefit for now?
Well, so there is an adjudicative pause, but that doesn't mean that it can't be lifted at some point. And a part of me suspects that the reason they did the adjudicative pause is because they knew that this memo was coming down, and their plan is to use this memo to deny the majority of the beneficiaries or the adjustment of status applicants from those 39 countries. They terminated TPS because they want the Venezuelans, the Haitians, the Nicaraguans, and the Cubans gone. They put a pause on their adjustments so they could figure out a way to deny all those applications. And they just figured that out. So while the pause does mean you're not going to get a denial while the pause is in effect, I think it's very likely that they're going to lift the pause on adjustments of status so they can apply this memo to deny people and put them in proceedings.
We have Javier Rodriguez. For someone who's been in authorized stay because of the immigration hold since November, is he in the most likely to request to be removed list?
I don't know what the request to be removed list is, but authorized stay is not status. So if you have a pending adjustment of status, a pending asylum, or any pending application for change of status, you're granted authorized stay, but that does not protect you from detention and removal. So if you get detained by an officer because you're driving and you run a red light, then they can give you a notice to appear and put you in removal proceedings. We also have clients that filed their asylum outside of their I-94 period, meaning they came in on a tourist visa, then they filed their asylum within the year, but after the 6 months, they're considered visa overstays and they're getting NTAs in the mail. So authorized stay does not protect you from removal.
We have, will someone waiting on 6018 approval benefit from joining the lawsuit? Also, could the lawsuit come back to haunt us in the end, like Mark against us in our case?
So, I mean, this administration does illegal stuff, but the law says that you cannot take retaliatory action against litigants in a lawsuit, and they're going to be watched, right? Like, this is one of the things why we do mass actions. If I'm filing a lawsuit for 300 people and then all of a sudden all of them get notices to appear or denials, the judge is going to intervene because it's obviously retaliatory. That's illegal. They can't take negative action against you because you sued them. So that's one of the protections of the lawsuit, is that you're under hypervigilance of the federal courts.
People applying for EB1, but not for adjustment of status yet, can do the litigation. What's the next step for them?
So we can explore whether or not you're eligible for consular processing and what that timeline looks like. If you're not one of the visa banned countries and you're safe to go home, consular processing may just be the best option once your EB1 is approved. If we have to adjust your status because that's the only option you have, then we would need to consider including the equities memo at the initial filing time, or you can wait and we can see if an RFE is issued and address it then.
Okay. If a green card process is denied, but you haven't maintained legal status as F1, do you lose your prior status? Do you lose the ability to extend that status or obtain another form of immigration?
If you've maintained your status throughout the pending adjustment period, you don't lose that status. You have your F1 and you can continue to extend your I-20s. I wouldn't recommend traveling to stamp the student visa because I think because of the adjustment, they might deny you at the consulate. But since you've already been admitted on the F1, you're entitled to the I-20 and you could just keep getting I-20s and extending your status. And then you can file a change of status to another status or reapply for adjustment in the future. You can also do the I-24 and consular process your immigrant visa, depending on what those timelines look like and whether there's a consulate that you can process at, because you're not subject to a ban.
So we have a question on Instagram. Does this affect the F1 visa?
No, this is only for adjustments of status to green card. This is for green card applications in the United States.
Aaron says, I may have missed this. So the standard EB2 AOS via perm and I-140 not expected to experience issues when filing the AOS, as long as you're not part of the 7539 bans countries?
No, you are absolutely going to have issues. This memo applies to everyone who applies for an adjustment of status. The 7539 country bans, really it's just that those people don't even have the choice of consular processing. So adjustment is the only option for them. So making it harder for them to adjust, it's a trap. But if you're not one of the 7539 country bans, you still have the same hurdles to overcome due to this memo. It's just that you also have the option to consular process that the 7539 country bans don't. So you may want to consider consular processing, but if you do decide to adjust, you will need to prove the positive equities. I think we have a few more questions.
Yes. So another question.
So the last one was from Aaron.
Can we join the lawsuit if the filed relative petition is also still pending, or is it just for approved petitions awaiting AOS approval?
You can absolutely file if your relative petition or your I-140 is still pending, so long as you also have a pending adjustment of status. The thing we're seeing is that for a lot of these nationalities, a lot of my clients are from one of the 39 countries. There's an adjudicative hold. And even though it's supposed to be a benefits hold, not a petition hold, for a lot of people, they're not giving them decisions on their I-130 and I-140 petitions. So a lot of the members of the lawsuit that have already signed up are people who still have a pending, I-140 or relative petition. But I think the strongest cases for this lawsuit are relative petitions. I mean, the fact that they're trying to keep US citizens and residents from being with their spouses while they process their green card is ridiculous.
Okay, we have Emiliana Herrera. If I'm about to become a citizen and plan to request my husband, is he gonna need to do it from our country?
So this memo doesn't mean that you can't file an adjustment of status. They couldn't make it illegal to do something that Congress authorized. But what they're doing is they're changing the standard of approval. So now instead of there being a presumption of approval, meaning you're approvable unless you're a bad guy according to this list of inadmissibilities, in which case you probably shouldn't have applied in the first place. That just means that you had a bad lawyer. Most people that file adjustments and are on paper admissible should be approved. They're now saying no. Only a small fraction of those people who file their adjustments and are approvable on paper are going to get approved, because it's not just about being approvable. It's about showing that you merit this extraordinary discretion and show that you have, exceptional or extraordinary criteria in your case to merit approval. So, you're going to essentially have to do like a waiver almost to qualify.
Okay, and then just that'll be our last question for today.
Okay.
But I would like to for us to tell us the three arguments or the three steps that people can take right now with this memo. Please.
So let's just sort of round up what is the conclusion of this. What they're doing, excuse my French, is shitty, but we're going to fight it. How are we going to fight it? One, we are going to file a lawsuit to request protection for our clients from the applicability of this memo. We're going to argue, as we will in every aspect of representation that we do for our clients, that this memo is illegal, that it cannot be applied retroactively to people that followed the rules and filed under the standard that existed prior to the enactment of this memo. And we're going to argue that even if you were to consider this memo, our clients merit favorable discretion. So step one is the lawsuit. Step two, we anticipate requests for evidence and that the issue will come up on interviews. So for those cases, as a request for evidence come up or as interviews are scheduled, we will offer the clients the option to have us prepare an equities memo and package and put together the evidence, similar to a waiver, so that we can argue that they merit favorable discretion. Every case will be different. The evidence for every case will be different. The arguments will be different. The evidence will be different. Some will be stronger than others. Some people will have more favorable equities than others. Some people will have more negative equities than others. And we're just going to do our best to make these arguments that you merit the discretion. I cannot guarantee that we're going to get approvals because I don't know what the government is instructing their officers, right? So that's how we're going to attack these cases. And obviously, as we start getting responses to requests for evidence, as we go to interviews. We're monitoring other colleagues are sharing template RFEs that they're already getting on listservs. We've gotten a couple of those, so we're modeling our sort of strategies for these cases. We got a client that's going to interview next week that we're already preparing a package for. So, this will be an evolving practice, and everything we learn on one client, we're going to share with everybody else for their benefit. The supplements, as we said, we're estimating about 10 hours of time to put them together. That'll be $37.50. We charge $375 an hour for our time on paralegal time, and then attorney time is $500 to $750 an hour, depending on the attorney. We're trying to keep this to paralegal time to reduce costs for the clients, but as the attorney, I'm developing all the strategies and the memos, then training the team so that you're essentially getting my work product, time, and knowledge for free. And then the third step will be having one-on-one conversations with clients as we're filing these cases to determine what's the best course of action for them. Do they want to file this as an adjustment of status, or do we see a path to consular processing their particular case based on the ban's exceptions, processing timelines, and whatever, every case is going to be different, right? So we can do that analysis with each client. Right now, anybody who has an adjustment of status pending and wants to switch to consular, just know that's going to be like a 2-year process. We can do it, but it will require withdrawing your adjustment, filing an I-824, and consular processing at your home country consulate abroad. Venezuelans, the designated consulate is Colombia, so that's where you have to go. Anyways, that's the 3 main things. If you're interested in the litigation, you can send an email to litigation@cfrlaw.com. So our main domain for all emails is @cfrlaw.com. You can email me, Michelle@cfrlaw.com. If you want to be in the litigation, it's litigation@cfrlaw.com. If you want to book an appointment, you can call, email us, or visit our website, cfrlaw.com, and you can book an appointment right on there. If you want to talk about your particular case, how this policy affects your case, happy to do that. But I don't recommend trying to book time with me to consider the litigation because my calendar is full this week, and the deadline to participate in the litigation is Friday afternoon. After that, we cannot include anybody else. And that's not my call. That's just the Federal Litigation Task Group. They have their team put together. There are several law firms that are participating in this lawsuit. So their cutoff to get all the documents and the client data is Monday at noon. And we need the weekend to put together the packages and declarations because every single case is going to need a declaration. Now, I have in the past recommended that our clients join other litigation, for example, impact litigation. I have some very smart colleagues that were, handling that litigation. And I had recommended clients participate in that. Now, those lawsuits were primarily on the benefits pause memos. They did not and do not, as I'm aware, have a case ready to file on this issue. But I also understand that their last case that they filed was dismissed, so they lost the case. And part of the reason that they lost was because the judge argued that it was kind of like a hodgepodge of claims, and they hadn't articulated a clear irreparable harm to the individual plaintiffs. So one of the reasons that the fee is, what it is in our cases, we are actively working with the clients to assemble the packages. And for the attorneys that we're referring to, we have to prepare complex declarations and arguments for the lawyers to use as to what the irreparable harm is to each one of our clients. So I'm making arguments for clients that are subject to the bans, outlining why they can't go home to their country of origin to consular process. For clients that have the pending adjustment, I have to show arguments about how long the I-824 takes and what it would imply for them to go and leave the country and now do the I-824. I have to describe the financial harm to my employer. So my employment-based petition applications, I'm going through an analysis case by case of, who's the employer, how will that employer be harmed, because they did all this recruitment to fill that position. On my national interest waiver and EB1 clients, I'm using their declarations to make the arguments of their incredible contributions and how, the United States, their employers, their clients themselves would miss out on their inability to pursue their careers here in the United States. So these are very fact specific to each plaintiff claims that we have to document. Whereas impact litigation was basically just telling people to fill out a form and upload a document, and they didn't even talk to the client. So it was kind of like they were just making their legal arguments, but not case specific factual arguments. And that's what we think caused those lawsuits to fail. So we're hopeful. We're filing down here in Florida. We've had the luck of, with this law firm that we're litigating with, Prada Dominguez. They're very, very bright, very competent, have had a lot of success in litigation nationwide in its Supreme Court in recent years. And we're working with them. They've had some very good success with the judges in our jurisdiction who seem to understand the issues very well, which is better than we've seen performance in other jurisdictions. So that's where we stand on the litigation. And with that, I will say my goodbyes. We are here for you. Our phone number, 305-579-9218. You can always call, make an appointment. That number is also WhatsApp. So you can message it and someone will get back to you. We now have after hours calling, even though we only work Monday through Thursday. Please know when you email the staff on a Friday, we have a 2 business day response time. So they will not answer you till Tuesday of the next week. They need 2 business days to respond. And we are not working on holidays. I got a bunch of emails from clients saying, I emailed you Friday and you didn't get back to me. I'm like, okay, well, we're closed Fridays. We were closed yesterday. Give us a day or 2 to respond. So please be patient. We are here. We are reading your emails. We are communicative. I have to say, I know the communication policies of the majority of my colleagues and the law firms that handle big immigration cases. It is not 2 business days. It is usually several weeks. So, I am very proud of my team for being responsive, but it's hard when people are critical. This is not immediate response time. We have thousands of clients. And as much as we want to give each one individual attention, we cannot when there's a policy change like this. And as you can imagine, everybody's inboxes were flooded this weekend. So contact us, follow us on social media, email us. We're here for you, and we'll get through this. Have a great day, everyone.